Hey, welcome, Faithful Politics listeners and viewers. If you are watching us on our YouTube channel, we are glad to have you here. And I am your political host, Will Wright, and I'm joined by your faithful host, Josh Bertram. How's it going, Josh?
Doing well, thanks, Will.
And this week we're going to be talking something. We're going to be talking about something that's pretty close to me. In Bremerton. So recently, SCOTUS had a oral arguments hearing for Coach Kennedy against the Bremerton School District. So we're going to kind of dig into that with two guests this week, actually. So one of the guests is Amanda Tyler. She is the executive director of BJC, which is Baptist Joint Committee for Religious Liberty. How's it going, Amanda?
Going well. Great to be with you.
And we have returning guest Brian Kaylor, who is a editor and president of Word and Way. So welcome back, Brian.
Hey, thanks to be back.
Yeah, and so let's start off first with you, Amanda, and maybe you can tell us a little bit about what is BJC, what is the work that you guys do, and maybe a little bit about your professional background.
Absolutely. Well, BJC stands for Baptist Joint Committee for Religious Liberty, and we are an education and advocacy organization that advocates for everyone's religious freedom. So we come at this from the Baptist perspective. We're supported by a number of different Baptist denominational groups, churches, and individuals, some Baptist, some not, who have different positions and theological ideas, but are all united around the importance of protecting everyone's religious freedom. And so in a constitutional sense, in the American constitutional sense, we believe in strong protection of the dual guarantees of religious freedom in the First Amendment. So we believe in a strong establishment clause or no establishment clause, as well as a strong free exercise clause, and that both of those protections are really important to protect everyone's religious freedom, people from all different faith traditions, and those who don't choose a faith tradition at all. BJC's been around for 86 years, and we are located in Washington, D.C., right on Capitol Hill, right behind the Supreme Court building. And I come at this work as a Baptist and also as a lawyer. And my professional background has been working in private practice, working for a federal judge, working for a member of Congress, and of course, for the past 5 years, leading BJC.
That's awesome. Thanks, Amanda and Brian. So
for
those that haven't had a privilege to get to know who you are or listen to your podcast, can you tell us a little bit about who you are and maybe what Word and Way does?
Sure. I'm editor and president of Word and Way. We've been around since 1896, started as a Baptist publication in Missouri. We continue to have a monthly magazine. We also have a podcast, Dangerous Dogma, and an e-newsletter focused on issues of faith and politics called A Public Witness. And I'm also a longtime supporter of BJC and really excited. I think everyone should check them out and follow their work. And Amanda and BJC are doing excellent work on Bremerton and so many other important cases. And so I'm really glad that you all have her here with me today.
Yeah, that's really cool. Yeah, we really appreciate both of you guys being here. And I just want to say, so
Absolutely, yes.
before we get into this, so this case in Bremerton has a special place in my heart. So like I'm from Bremerton, and I was actually there the week that the Supreme Court thing was going on, and I drove by the high school. It was pretty dead. I mean, like kids were going there, but like, so when we lived there, we used to have a foster daughter and we used to go to Bremerton High School pretty regularly and go to football games, what have you, and we all knew about this case, about this coach, but we didn't realize it would kind of rise to the level of, Supreme Court stature, which if you talk to any Bremerton person that's politically involved, I would venture to guess most of them would be less excited about how this case rules and more excited about Bremerton made it like in the national news, because like I live in Virginia now, so whenever I tell people that I used to live in Washington State, they're like, "Oh, where?" And I would just say near Seattle, because like nobody would know where Bremerton is, So to all my Bremerton, listeners and peeps out there, like we made it. You can now claim you're from Bremerton. So there you go. but anyways, more seriously,
That's
though,
awesome.
can you why don't you start us off? And we'll go with you, Amanda. If you can just start us off, briefly describe to us kind of what the case is about. Maybe who the people are that were arguing it, and what are some of the major issues they were arguing.
Absolutely. And Will, I'm so glad to know that. And I think that's a really important personal connection. We can get really divorced from the people and the reality of these cases when we just talk about them by the name that the court knows. But these are real people. These are real places. And so I really appreciate your leading us off that way. Well, this lawsuit was originally filed by Joseph Kennedy, who was an assistant coach for the varsity football team for 8 years at Bremerton High School in Bremerton, Washington. And for those 8 years, Kennedy delivered prayers to students in a variety of ways. At first, he stood alone on the 50-yard line at the end of games, but he also led and participated in both pregame and postgame locker room prayers. And his prayer practice eventually evolved into students joining him with his permission for these on-field prayers, that players would kneel around him, and sometimes even coaches and players from opposing teams would join him in this practice. Well, Bremerton School District did not actually learn of Kennedy's prayer practice until September of 2015, when a coach from another school actually said something to Bremerton High School principal, like, hey, it's really cool that you let your coach pray like this with students. And the principal was like, oh, I didn't know this was going on. And so the district at that point told Coach Kennedy, look, you're free to engage in religious activity, including prayer, but that can't interfere with your job responsibilities. And you have to do it in ways that are non-demonstrative, so that it as long as students are also engaged in that conduct. Or you need to do it in a time and a place when students are not able to engage in the conduct with you. And at first, Coach Kennedy complied. The very next game, he gave a non-religious post-game speech, and he came back to the field at a time when everyone had left and prayed in a private way. And that was completely permissible to the district. And if that were the end of the story, we wouldn't be talking about it 7 years later with the Supreme Court case.
Yeah.
Well, a month later, Kennedy's attorneys from First Liberty Institute sent the school district a letter, and they demanded the district reverse its earlier decision, and they notified them that Kennedy would immediately continue his practice of verbally and audibly praying at the 50-yard line immediately after games, and he would do so starting at that week's homecoming game. Okay, so at this point, the district responded and said, again, look, we'll work with you, we'll find another way, but you can't do this. Kennedy went ahead and did it, but he didn't do it alone. He actually had, at that point, acquired a lot of media attention, the attention of a state legislator, and there was such a rush and crush of spectators running onto the field to join him at that game that it became a real spectacle. It was such a spectacle that the district actually had to place robocalls to parents before the next game saying there would be no public access to the field.
Gosh.
They posted signs and they made announcements. I mean, this is kind of a lot of context, but I think it's really important because Coach Kennedy in this case is saying that he just wants to have a private prayer. That this is, at this point, because of all of this spectacle, it had really ceased to be a private prayer.
Right, it's not private anymore.
Yeah, exactly. In the place and doing it at the 50-yard line. So, the district came back and said, again, we will accommodate your religious exercise, and we can help you find a place that you can do it. We can help you find a time, but you have to stop this practice. And Coach Kennedy refused to stop, continued to do it. And at that point, the school district said, look, we're going to place you on paid administrative leave. Again, I want to point this out because a lot of people are saying that Coach Kennedy was fired. He was not fired. He was placed on paid administrative leave, and then for the rest of the season. And then when his contract came up for renewal the next year, he did not apply for the job again. Also, this is an et cetera point, I think, but the head coach, Coach Kennedy was the assistant coach of this team. The head coach also did not reapply. He said because of the negative, unsafe situation that Coach Kennedy's actions had created. So we really had this practice had really turned into quite a spectacle. Well, at that point, of course, Coach Kennedy filed a lawsuit. He lost in the lower courts. He first sought review at the Supreme Court at a very preliminary stage of the case. This was a few years ago. Supreme Court declined to hear it then. But Justice Alito wrote a short statement criticizing the way that the trial court had handled it, went back down. The trial court, found all their facts. They again ruled against Coach Kennedy. The Ninth Circuit Court of Appeals affirmed that ruling. So he lost again. And then he sought review again from the Supreme Court. And that brings us to where we are right now.
Man, that is such a complicated process. It's amazing. My mind is kind of spinning right now, if I'm honest. Brian, what do you think about all this? What's at stake here in this case?
Yeah, and it's not just that it's complicated. It's frustrating that the clear facts of the case keep getting miscommunicated. And I would say some people are just being dishonest as they talk about the case, continuing to claim that, this was private prayer. I mean, we've seen this even in some of the briefs that were filed with the Supreme Court when clearly the record shows that it came to a point where it was not private prayer. I always think of that line from The Princess Bride. You keep using that word. I do not think it means what you think it means. This was not a private prayer practice. It wasn't a fleeting prayer, as the attorney for him argued with the Supreme Court justices. He wasn't terminated. All these things that Amanda just said. And that to me is, I think, really frustrating outside of the legal implications of the case. Is I'm concerned by how many Christian advocates and Christian pundits that are pushing for Coach Kennedy's case here are bearing false witness about the facts of the matter. And there comes to a point that if we have to lie about prayer to win a case, I think we've already lost. And so that's what that is. It's not just that it's complicated and being in some ways deliberately complicated. It's frustrating to see. That we can't even, even the point that Justice Breyer this is very unusual. He's like, all right, we just need to have some questions about what are the facts of the matter. Like normally the Supreme Court all arguments, Amanda's an actual attorney. I just play one. And so I know Will, we watch C-SPAN and watched you guys on C-SPAN, right? And, we listen to oral arguments just kind of for fun. But you don't hear the justices being like, hey, what are the facts of the matter? It's all about what does it mean and how should they rule. But it's been so confusing in this case that he had to spend quite a bit of time just trying to figure out what is and isn't true. Yeah, so that's really frustrating.
I'm curious. So this is sort of a tangent, but Josh, like you used to be a coach, right? Like an assistant or head coach and coach.
Yeah, totally.
Team. Like how many times did you pray like after games or before games at the 50-yard line?
Never. I never did.
You're godless.
There were a couple of kids that were. So there was one time where there was a young man who we thought had injured his spine, and it was during practice. And so I was kneeling down with them, and he was pretty upset at the prospect of having potentially like a permanent injury, and I asked him, do you want me to pray with you? And he said yes, and I did. So I think that's the only time. They knew I was a pastor. They knew, they knew that about me, but that was the only time. And it felt like appropriate in that moment. So.
That's really awesome. Yeah. And well, going back to the topic at hand. So during the arguments, I actually managed to listen to all of the arguments and whatnot. And for a non-lawyer type like myself, they mentioned a lot of different like court cases. And for me, like I like to kind of get into the weeds. Like I'm the guy that reads the footnotes, So they mentioned a couple that I thought maybe I could just throw your way and give us sort of the Reader's Digest version of them. So one of them's like the Lemon v. Kurtzman endorsement test. What's that?
So Lemon is a case back from 1971, and I bet you heard it mostly coming from Justice Gorsuch, who really doesn't like Lemon, and Justice Kavanaugh, who dislikes Lemon maybe just a little bit less than Justice Gorsuch. So Lemon came up with a 3-part test to determine whether something is a violation of the Establishment Clause. Now, importantly, Lemon v. Kurtzman is not a case from the public school context. And so it sets out a test, but one which is not directly on point to the cases here. And but it is something that is largely out of favor. I think a lot of these operationalized tests are difficult to apply in different types of situations. There's no one-size-fits-all test to determine whether something is a violation of the Establishment Clause. As someone who believes in a robust Establishment Clause, I readily admit that. Mm-hmm. That doesn't mean that the Establishment Clause is a bad thing. It means that we have to think about the overall meaning of the Establishment Clause. What's the purpose of it? The purpose of it is to keep the government out of religion's business, to say that the government has a role that is distinct from religion. It is not the government's place to either promote nor denigrate religion, and that can show up in a lot of different contexts. And so we heard about Lemon really from Lemon's detractors, and I think some people think, if Justice Gorsuch writes the opinion in this case, then I predict right now that Lemon will forever be in the trash can for future cases. But that does not mean that the Establishment Clause is. And I'd love, once we get into some of these other cases, maybe we can get to that.
Yeah. So how about Garcetti?
Yeah, so Garcetti, and I'll put it here also with Pickering. Mm-hmm. These cases really go together. Pickering is a case from 1968. Garcetti is a case from 2006. And these cases taken together look at the free speech rights of government employees. Now, again, importantly, neither of these cases is in the public school setting. And also, neither of these cases involved religious expression or speech. So they are not really perfectly on point to help determine how this case is going to play out. But the gist of these cases is in determining what the contours of the free speech rights of the government employee is. We look first at whether the employee was speaking at the time as a government employee, or were they speaking as a private citizen on a matter of public concern. If they were speaking as a government employee, that is doing so, within their job duties while they're performing their job duties, then the free speech clause doesn't apply, and the government has great latitude in restricting their free speech. But if instead it looks more like that they are just a private citizen speaking on a matter of public concern, then the employee doesn't automatically win, but we look at a balancing test. We look at, what is the government's interest in the effective and efficient fulfillment of its responsibilities to the public, doing whatever it's supposed to be doing then. We look at the rights of the employee, and we look at the rights and interests of the public. And so the parties who briefed this case, First Liberty Institute on behalf of Coach Kennedy and Americans United for Separation of Church and State on behalf of Bremerton School District, really focused on this question, this government speech versus private citizen question, and are, briefing and arguing, about whether he was, this is government speech or just private citizen speech. I
got it. Okay, and the last one, Tinker? I think that's right, like Tinkerbell? I don't know.
Yeah, Tinker. And I'm going to add some. So Tinker is a case from the public school context, but again, not dealing with religion. This is the case about whether students could wear black armbands to protest the Vietnam War. And the court in that case said that they could. And the famous line from that case is that students and teachers do not shed their constitutional rights at the schoolhouse gate. And so we heard this line over and over again in this case, again, here focusing on the teacher's rights, not the student's rights. Mm-hmm. But the problem is, and just using this, kind of lightly like this, is that Coach Kennedy's lawyers were making it sound like teachers and students have the same rights. And when it comes to religion and religious expression in the public schools, they do not. Because the teachers don't just happen to be adults who happen to be in the building. they are employed by the government. They are agents of the state. And because we have this other long line of constitutional cases about religion in the public schools, teachers have different duties. And so this line of cases goes all the way back to 1962, Engel v. Vitale, where the Supreme Court prohibited state-sponsored, school-sponsored prayer, and they did so in order to protect religious freedom. And the Supreme Court has reaffirmed that principle that is now 60 years old. They reaffirmed it in the context of high school graduations in a case called Lee v. Wiseman. And they reaffirmed it, believe it or not, in the context of high school football games. They did it in the year 2000 in Santa Fe versus Doe, a case that comes out of, not of Santa Fe, New Mexico, but Santa Fe, Texas, where football is a kind of religion in and of itself. And in that case, it wasn't a coach praying, but a student praying. Now, again, remember, students have different rights, and students have more rights to pray in public school than teachers do. But in this case, the school ran an election to elect the prayer. They also used the loudspeaker that was provided by the school in order to broadcast the prayers to everyone gathered in the stadium. And the Supreme Court held that violated the Establishment Clause. And so now we have this case where we have not a student, but a coach, a teacher, an agent of the state doing the praying. And we heard Santa Fe v. Doe a lot from Mr. Clement, who was representing or arguing for Coach Kennedy in this case. And he was trying to say this would be such an extension of Santa Fe versus Doe because there's no loudspeaker. He's just doing it on the field. Well, my immediate thought was, no, you're missing the point. The coach is the loudspeaker. Yeah. The fact that it's the coach praying makes it school-sponsored prayer. You don't need an amplification system to make it school-sponsored prayer, which is prohibited by the Constitution.
So, Brian, I'm just curious to find out some of your thoughts. You know, I'm watching your facial expressions and like certain things hit me like, oh yeah, and like I can tell you have something to say. But so, what does it mean that students have more rights than teachers? Normally, this is the reverse, right? Adults have more rights than those who are minors or under a certain age that we've defined. That's the barrier between, adolescence and adulthood. And so what is, why is there the reversal in this case?
Yeah, that's a great question. And, I think it really comes down to that issue of coercion, particularly, the power and the influence that a teacher or coach can have on students. And, as a father, I was thinking about that during the oral arguments with some of the examples that were mentioned. Justice Sotomayor was asking about hypotheticals that were actually in a classroom as opposed to on the football field, which is still school property and, on a school event time. So she was trying to say basically how we rule in this case could impact other school property moments like in a classroom. And some of the line of questioning is like, as teachers in the classroom, kids are coming in, could the teacher start praying or encourage, the students to gather with the teacher to pray? And the lawyer for Coach Kennedy was basically coming down to, well, if the bell has rung to start the school day, then sure, that's not allowed. That would be clearly a problem. But maybe if it's before the bell, then, there could be some, the teacher could be praying at their desk, maybe even out loud, reading the Bible. And I had some real problems with that. I'm not sure if that attorney's very familiar with public schools these days. I mean, my son can be in the classroom up to 30 minutes before school starts. And particularly with COVID, that's where they eat breakfast that's a procedure that's been going on for a couple of years now. And so they're in there eating breakfast for 30 minutes. And the teacher is already the teacher. The teacher is already on duty. The teacher, even though the bell hasn't rung, artificially starting some sort of line of separation. And I don't think it would be appropriate for the teacher to lead a prayer time with the students. Now, if a student wanted to pray over their breakfast, right? That's fine. This is that idea that the students do have more rights to to express themselves. And as you know, the Engel case that Amanda was just talking about is sometimes talked about being, God was kicked out of schools. When all it really did was stop government prayers, official prayers. I mean, Josh, I'm sure that the God that you preach about every Sunday cannot be kicked out of a building by, 9 people wearing black robes. I mean, it is, God wasn't kicked out of school. And as, one of Amanda's predecessors liked to always joke, as James Dunn, as long as there are math tests, there will be prayer in schools. Right? And so, we've all been there. We did those prayers, when we were getting ready to take the test. And so, sure, the students can pray. They can pray over their meals. They can pray before a test. They can't be disrupting others in the classroom. And same with the teacher. The teacher cannot be creating a situation where they might coerce a student into that prayer. And I think that's a really important distinction here that has to be centered. The religious liberty rights of the students. In this particular case, the players as students, but the students at any sort of public school setting.
Yeah, I just want to make a quick point of order and correct the record, because Josh doesn't have service on Sundays. He has it on Saturday nights.
All right.
Yes.
Well, that God can't be kicked out of school either.
Nope. Definitely not.
Yeah. So to kind of keep with what you were saying about this, Brian. So everybody here is probably familiar with who David French is. He's pretty good writer for the Dispatch, formerly National Review. And weird, like, oddly enough, I agree with probably about, 80% of all the stuff he writes. So I think he writes well. He represents Christianity, I believe, like, in the right lens. But he wrote an article in The Atlantic recently called Let Coach Kennedy Pray. And the article he cites Island Trees District versus Pico, which maybe here in a second you can kind of tell us what that is, Amanda. And then she's like Googling, and then he says he makes an argument that public education prepares students for active and effective participation in the pluralistic, often contentious society in which they will soon be adult members. He continues by saying a vision of public education that walls off students from their teachers' personal expression doesn't prepare them for pluralism. It does precisely the opposite, teaches them that majorities can and should control speech, and that the remedy for exposure to offensive ideas is an appeal to state authority to quash personal expression. So Brian, why do you agree or disagree with that statement?
To me, I agree with a lot of what he writes, and I share some of it approvingly on Twitter. And this one I disapprovingly wrote about on Twitter, because I think there seems to be this idea that somehow, I guess, secularism is the majority opinion, and that's what's walling off. Christianity is the majority opinion. And so in reality, what's happening here is we are protecting the minority rights. And I think that is still really significant. And this has been the jurisprudence for 6 decades, as Amanda outlined. And I think it's a line that's really important to stand. I mean, if you've got a football coach you want to be in good graces with the coach because you want to play next week, there's a lot of coercive power there from the coach, and some of the students in this case have specifically talked about the fact that they felt coerced, that even though that they didn't believe that way, or their faith didn't lead them to pray in that way, that they felt like it might hurt their playing time if they didn't. And so I think that while I think his big vision is correct, I think he's misunderstanding how do we teach students to live in a pluralistic society that values and respects all perspectives, particularly those of minority opinions that are most quickly and likely to be squashed.
Got it.
So, I totally hear what you're saying. One of the questions that came to my mind as you were talking is, what about, does this coercion extend past certain times and geographic places? Like, if it was on a Sunday, they go to the same church or whatever, or, they see them in the store and they get into a conversation, it turns spiritual. Is that some violation, do you think, of church and state? Because he's always going to be that role whether or not he's acting in an official capacity.
I mean, Amanda can get to the legal side. I do think that there's a difference between in the job at school and outside of that. And so we have to be careful that we're not squashing teachers and coaches' religious freedom rights at church, at home, in the store. And so I think that there is an important difference.
Yeah, absolutely. And that point was actually made in the oral arguments. I think it was Justice Barrett who was questioning about this. And, one could imagine a scenario. That's what happens in these oral arguments. They come up with these kind of crazy hypotheticals because they're trying the justices are trying to figure out where to draw the lines in the case, right? And so in most cases, once you're off duty, you really are a private citizen. You're not the agent of the government in every moment of your life. But when you are on duty, when you are coaching a football game and on the 50-yard line, as soon as that game is over, then, I think that you are well on the side of being government speech. But one could imagine a situation where Coach Kennedy might put on his Facebook page, I think this was the example from the oral argument, in all of my years of playing, I have never played someone who wouldn't pray with me, right? That's coercive. He's posting that in times when he's not on the job, not on duty, but there's an example of where coercion might cross the line. But that's a pretty extreme example, and I think in almost all cases, it's only when someone's actually on the job that the restriction against school-sponsored prayer would be in place.
Right. I guess what I'm trying to understand is the correlation maybe to personhood. Like, all right, how can I say this in the right way? If you are, like, let's say that the coach, he's acting outside of his job role, or anything else. And then when he's in his job role, like, can we really, would you call everything that a teacher says at the school building government speech? Wouldn't that be a little bit dangerous to equate those things? I don't know. I'm not, it's just kind of, it's one of those strange things in law, and I'm not an expert, but I've done enough reading and trying to read in law that there's like these like imaginary things that are drawn, in the sense, intangible, I should say, rather than imaginary.
Yeah. And Amanda would be, before you answer that too, I think this would be a good place to tie in. There's an argument that was made about like Ash Wednesday and like putting like, whatever the ashes on your forehead. So kind of to Josh's question, like, is that government speech?
Yeah, no, absolutely. And I think that's the point, Josh, that I think David French is making in his article is like that teachers aren't robots, right? And we can't say that every single thing that they do in their job is government speech, that doesn't make sense. And as a rhetorical point, I largely agree. One place I really departed from in his article, he says in there, this case isn't mainly about prayer. I'm like, actually, I think it's all about prayer. And he uses all of these examples that are more like political speech, right? And I think that's a whole nother question. And the reason that this is about prayer, the reason that we are particularly protective about teachers not leading in religious exercise is because we are particularly protective of religious freedom. That parents should not be afraid that the school is going to interfere with their religious decisions, with their religious instruction, or their lack of religious instruction when they send their kids to public school. And for that reason, we have special rules when it comes to religion. And I think that nuance is somewhat lost in French's article. And he's trying to have a bigger conversation about government speech that isn't always applicable here. But on the point of the Ash Wednesday, and this again was an exchange at the oral argument. This was between Justice Kagan and Mr. Clement. And this, again, somewhat frustrated me, as Brian was saying earlier, that, that kind of being deliberately confusing about some of these issues. So she's asking the question, well, what would happen if a teacher got up and said, look, I am here not for the school district. I'm here only in my personal capacity. Prayer is really important to me. And so now I'm going to lead us in a prayer. She said, would that be okay? And so he says, well, let me give you an example. A teacher walks in with Ash Wednesday ashes. And she's like, no. That's a whole different situation.
Okay.
And the different situation is, at that point, the religious exercise has already happened. There's nothing that the teacher is doing to invite the students to participate with him or her. And I agree completely that there is a record of coercion here. But I think an important point is that coercion, while sufficient to prove a violation here, is not necessary. All of these school prayer cases, they allowed students to exclude themselves from the religious exercise. So the idea that you could exempt yourself was never enough to save an Establishment Clause violation. The whole point was that we don't allow state-sponsored religion because we don't want the state telling us how to practice religion or whether to practice religion at all. So I think a closer analog to the prayer situation would be if the teacher said, okay, it's Ash Wednesday. I know many of you won't have a chance to go to Mass today. So we're just going to take a break here. And in my private capacity, I will impose ashes on anyone who would like to come up here right now and take the ashes. That would be clearly not allowed. But
Yeah.
for a teacher to express their religion, to come with ashes on their forehead, that does not violate the Establishment Clause. And to raise those examples really, I think, is disingenuous here and kind of raises the scare factor of what's involved in this case.
So in other words, like teachers having like an altar call at the end of each class is a no-no?
That wouldn't be appropriate. Shoot.
Hard
So I
to believe we're
shouldn't
having
have
that
tried to-
conversation.
So I shouldn't have spoken in tongues on all and tried to cast demons out of all those middle school boys. All right. Anyway,
Maybe off air you can talk to Amanda if you need an attorney.
so I guess one of my questions is, so you have the law making distinctions between types of speech. And I'm curious to get both of your takes on this. What is it about prayer that puts it in a category of its own, that it even would be a type of speech that would be considered offensive to begin with? What is it about prayer that makes it a different type of speech, which either could be a protected speech, or it could be deemed that it's not protected because it's too much of a violation of the Establishment Clause? Does the question make sense?
I think so. I mean, I would say it's not that the speech is offensive. It's rather that prayer is at this interesting kind of vortex of free speech and free exercise coming together. So there's a whole body of free speech law that's like the Garcetti Pickering that we were talking about. Then there's this whole area of free exercise law, which are in a lot of cases they're outside, even the conversation of this podcast. And then we have, free speech, free exercise, free expression that comes together in the example of prayer, particularly government-sponsored prayer in the public schools. So again, it's not that that's offensive speech. It's just that we have a constitutional rule that says the government won't take sides when it comes to religion. And the government in public schools are the teachers, are the coaches, are the administrators. So we have a rule against teacher-led prayer.
So I just didn't think, so I appreciate this feedback. It's awesome. What about like a president, like praying or something like that? Like, how, presidents pray, like, what does that fall under?
Well, I see Brian's written and talked a lot about this.
Is a president
so I don't know
ever not acting? But this is interesting, because is a president ever not acting in capacity as a president?
Well, and we can talk, but I just want to again focus that we have very special rules in the public school context. And that's for a number of reasons. One, it's compulsory. that one has to send their children to school. Two, that they're young people, highly impressionable. And so we have extra rights for public school students. And we have this whole body of law, not just the cases we mentioned earlier, but bipartisan approved guidance that has come from the Department of Education for every administration since Clinton. So Clinton, Bush, Obama, and Trump all reaffirmed this kind of careful balance that we have here. So there's a whole body of law around public school expression of religion that is directly relevant, that means that we are even more protective of government-sponsored speech. And I mean, so the president praying is more like ceremonial religion, is more of an example, that hasn't ever been held to violate the Establishment Clause. It might raise other questions that involve religious freedom. Not everything that is constitutional is a good idea when it comes to religious freedom for all. So that's a whole conversation. But when we talk about constitutional violations, the public school context is a unique set of law.
Did you have anything to add on that, Brian?
Yeah, I mean, and that's a great point. I mean, you're not required to watch the president, so you can always turn the channel if you don't want to be part of the prayer. But I think one of the issues here that I think gets to your question, Josh, and so is I don't think we have a great in the law and in our public discourse an understanding of public prayer versus a private prayer. I mean, because public prayer is where we start to hit this intersection of its religious expression, it's free speech, and I felt this came up. There was Justice Barrett. There was another justice, and I forget which one. There was a couple of justices that were asking questions. I think it was Roberts asking about, he's praying and it's audible. Like, why is this a free speech argument? Who is he talking to? And his attorney's like, oh, he's talking to God. And it's like, I mean, that's true to an extent, but that's private prayer. Public prayer has multiple audiences. And so, I won't put you on the spot here, Josh, but I mean, I'll be honest, I've sat in some churches where some pastors are they remember a point that they've forgotten the sermon and they'll kind of work it back into the prayer. God didn't need to hear that. That was to the other audience, right? So public prayer has multiple audiences, and I feel like that aspect gets lost in a lot of the conversations about prayer. Oh, you're talking to God, so therefore it's protected free exercise. It's like, well, there's also other people hearing you. And so this does raise the establishment questions, or so on and so on and so on. And so I think that's part of the confusion, is thinking about different types of prayer.
That's interesting. So recently there was like a 9-0 opinion in the Boston flag flying case. And I'm curious, one, if you can just give us your hot take, and then two, like, does that case give us any window into the justice's mindset on ruling on this Kennedy case? And either of you can answer that. I'll go Brian, because
all right, sure. Yes, obviously we see a few clues, but I also think we see some really significant differences. In oral arguments, for instance, justices like Sotomayor and Kagan were clearly skeptical of the arguments by Coach Kennedy, whereas they were not having that same sort of skepticism against Shurtleff, who had brought the Christian flag case. And so I think it's pretty obvious that this case, the Bremerton case, will not be a unanimous decision. And then the other thing is, we had the majority opinion actually only had 6 justices actually sign on to it in the Christian flag case, and by Breyer, and it's really a free speech case argument. He doesn't really make it into a religious establishment question, and I don't think they can avoid that as much as they did in that majority opinion in the football case. And I do think we see what Gorsuch is going to write. He's very sour on Lemon, and he spends his whole time writing about that in his concurring opinion. And I'm sure in hopefully a dissent, or whatever he's writing, be it majority, concurring, or dissent, he'll be complaining about Lemon as well in this case. So I mean, there's some hints, but I don't think there's any reason to suggest that it will be the same line, because I'm pretty confident it will not be a unanimous decision.
That's interesting. What about you, Amanda? What do you think?
Yeah, I mean, this flag case is so particular to its facts. I mean, really particular to this particular flagpole in Boston. And we saw Justice Breyer and his New England, status come out in the writing. It's kind of a fun opinion where he's talking about Boston City Hall is the ugliest building in America.
Brutalist architecture gets no respect.
And kind of an interesting point. Justice Breyer, in his long career, has never written a majority opinion in a church-state case. And so this, again, wasn't a religion clause case. It was a free speech case. But this might be the closest he's ever come to writing a majority opinion. But in that case, again, the government speech was a flagpole. I feel like a broken record. It was not in the public school context where we have very special rules, very protective rules. I think in that case, it wasn't, it's a situation that could be easily rectified. If Boston didn't want to have all people there, they can change their policy. And the justices said that in this case. The only other clue, I totally agree with Brian. I don't think the Bremerton case will be unanimous. I do think that in some way Justice Gorsuch will talk about Lemon. And the only other tea leaf to read here is Justice Alito also wrote a concurring opinion where he talked about his view of what the government speech doctrine should be. And I'm calling it the public information officer role. He basically says that the only thing that should be considered government speech is a person whose job it is to speak on the government when they're delivering a government-approved message. Okay, so that is a super narrow idea of what government speech would be. And so if he were writing in this case, obviously Coach Kennedy is not a public information officer. So he wouldn't think that this would be government speech, I think, if he were writing. But he only had Justice Gorsuch and Justice Thomas join him on that opinion. So I don't think that we have a majority of the court who is going to go with limiting government speech in that way.
Got it. Are there any similarities between this Kennedy v. Bremerton case and say like the teachers' speech in the parental rights and education bill in Florida, or like the Don't Say Gay bill? I mean, it's like for me, just sort of the casual observer, it seems like there's some similarities. Am I off the mark here, or are there? We'll go with Amanda.
Sure. I mean, I had the same thought, Will, when we started like really diving into Bremerton and thinking about what the motivations were here. Because again, one of the chief motivations for saying no state-sponsored, no school-sponsored prayer is because we protect the religious freedom rights of the students. And some of the proponents of the bill in Florida are kind of saying the same thing. We want to protect students from hearing certain things in school, and so we're going to say you can't say these things in school. Another bill that we've been tracking has been introduced in Oklahoma. I don't know if you've seen this bill, but it would make public school teachers personally liable for promoting positions that are in opposition to students' closely held religious beliefs.
Whoa.
Okay. I mean, there's no limit. And not only that, but for every incident, a teacher is fined a minimum of $10,000. Now, the average public school teacher in Oklahoma makes $42,000 a year. So this would obviously have an incredibly chilling effect on saying anything that could possibly ever be against someone's religion. Hopefully this bill is going nowhere, but this idea that we're there to protect students is totally missing from the conversation in Kennedy versus Bremerton. The advocates for Coach Kennedy are completely focused on Coach Kennedy and what his rights are, when it's really important for us to look at the entire school community. Of course, the students, the parents, and the broader community that are supporting that public school and expect the public school to not be promoting or denigrating religion.
Got it. What about you, Brian?
Yeah, I mean, and so if you hear from Amanda's answer, you almost have this hypocrisy, if you will, right? So on one hand, right, we're gonna protect students from hearing anything we don't like from a teacher, and then on the other hand, we're gonna support our coach to say and do whatever he wants, no matter what the students' religious beliefs are.
Yeah.
And so, but it's not hypocrisy because the common thread is Christian nationalism, and that's really what this is about. A lot of people who are lining up to protect this prayer at the 50-yard line would throw a fit if Coach Kennedy was instead Muslim or, a Satanist or, whatever, and wanting to hold that religious service at the 50-yard line at the close of the game. And we see this. I mean, we're seeing this in a couple of recent cases in North Carolina and Pennsylvania of Satanist clubs wanting to have an after-school gathering in the public school, just like Christian clubs already get. And you have to have equal access. If you allow one, then you have to allow the other. And there's actually efforts to ban this, based on the religious practice. And so, that's a perception, an understanding of religious liberty that isn't really religious liberty. It's Christian nationalism, because if it's not religious liberty for all, then it's not religious liberty at all. And so that's the common thread, I think, that you're finding there, Will.
Yeah. Well, Brian. So with all the great work I know that you do, kind of advocating for separation of church and state, and the same for you, Amanda, and your organizations. I'm curious to kind of get both of your guys' takes. And Brian, I'll go with you first. On like what are the ramifications of SCOTUS ruling in Kennedy's favor?
Yeah, I mean, so the big picture here, and that is a really important question, and I don't think they won't go this far in this case. But the big picture here, the big goal is the 1962 Ingle case that Amanda already talked about, and that was the government prayers in school. We could see this. I mean, Franklin Graham was on Fox News right before, and his organizations filed briefs supporting Coach Kennedy. Like, this is a target. It's a target that they would like, that some who hold to Christian nationalism would like to remove. And so that's the big picture dynamic. I don't think they would go that far in this one case, but it is about chipping away at that wall separating church and state, and particularly protecting the religious liberty rights of students. And so I think that's the agenda, right? That's the direction, the push that this is heading, is how do we get back to where we can sanction official government prayers in schools. And by the way, we know which religion those prayers will be. Right, they'll be those of us that are in charge. It's how do we get our faith codified and taught and practiced in the public schools.
Got it. Well, what about you, Amanda?
Well, first, I think a lot of people who are Supreme Court watchers, and I've read a lot of the articles after this argument, many of them are already predicting a win for Coach Kennedy. But we have to always, in these cases, we have to read the opinion, right? And so just because he might win this case, it'll be really important to see, and I'm not saying he necessarily will, but if he does, will be really important to see how the justices arrive at that point. And for us, for BJC, something I didn't mention earlier, we actually filed a brief in this case. We file friend of the court or amicus briefs in this case, and we filed a brief on behalf of some other religious organizations, both Christian and Jewish, and all of our groups have been active in promoting religious liberty in the public schools, and we have engaged in efforts to increase understanding and reduce conflicts like these in these cases. And for us, this case is very significant because it has the potential to either reaffirm or severely damage what has been settled law for many decades. And that is the constitutional protection for religious liberty in public schools. And how we do that is we say that teachers, coaches, and administrators do not lead students in religious exercises or otherwise use their government positions to advance or denigrate religion. And it's hard for us to see, that's why we filed a brief on behalf of the school district in this case. It's hard for us to see how you can draw a line between what Coach Kennedy is trying to do here and some of those hypotheticals from oral argument of a teacher wanting to engage in some of this activity in the classroom. Because the football field is Coach Kennedy's classroom. And so how do we draw the line here and not really chip away or drive a truck through those protections that have been in place now for 6 decades?
Yeah, that's really good. What are the odds that we will get a leak to Politico about the ruling?
or Word and Way, if anyone's listening would like to leak a draft, just send me an email. We can work this out.
Yeah. Like I'm sure you can send it to like wordandway@protonmail.com, and
I need to get that set up. You're right. Yeah, this is the new
or
age.
Signal,
of
or something like that. But no, this is great. I really appreciate both of your guys' insight. What are any last minute thoughts about the case? Maybe stuff that we didn't address, or anything that you think is important for people to be thinking about as we wait for the ruling? Amanda?
Yeah, I mean, one thing is there's a way that you can just kind of dismiss this case. So it's just this one football coach in Bremerton, Washington, important place that we all know now where it is. But what does this have to do with my life? Well, public schools serve 90% of American population, and students in these schools come from all different kinds of religious and non-religious backgrounds. And they are entitled to an education and to have these opportunities without regard to religion. That's what helps religious pluralism flourish. In David French's piece, he's talking about pluralism. Well, the best way to protect pluralism is to keep the line where it's been, that says no to government-sponsored prayer and says yes to all different other kinds of respectful religious exercise by students in the public schools. This has been agreed to by people from all across the ideological spectrum. I mean, anything that Obama and Trump agreed on, this has to be something that should be non-controversial and values that promote religious freedom and that we would want to see affirmed in this case.
That's awesome. What about you, Brian? What are some last words of wisdom for you?
Well, we focused a lot, obviously, and rightly on the legal side. And I do think that Justice Sotomayor raised an interesting question when she asked, what religion requires someone to pray on the 50-yard line? And so, I think, just let Jesus spike the ball on that one, right? When you pray, do not be like the hypocrites, for they love to pray standing on the 50-yard line to be seen by others. Truly, I tell you, they have received the reward in full.
Oh my gosh, I'm going to quote that. Maybe that might be the pre-roll. I don't know. I got some ideas here, but thank you so much, Amanda Tyler from BJC, and thank you once again, Brian Kaylor from Word and Way. And I guess we will.
Thank you so much.
We will be all patiently waiting to see what happens, and thank you, listeners and viewers, for tuning in. So until next time, we will see you all later.
Bye.
Bye.
Bye. Thank you.